All right. Can folks hear me? All right.
Yep, we hear you.
Well, we'll get started then, since we have a large group and some guest speakers and a lot of questions that have been submitted. Thanks for joining us. My name is Eric Hauge, Executive Director of Homeline, and you are joining us on Wednesday, October 14th, 1:30 in the afternoon for another one of our webinars on tenant-landlord issues, the eviction suspensions, and other related topics during the pandemic. Today, we're going to be joined by a couple guest speakers from Mid-Minnesota Legal Aid. Before we get started with our guest speakers, just going to run through a couple items. Just a reminder about what Homeline is. We're a statewide nonprofit organization. Our main program is a free and confidential legal hotline that any renter can call and get advice about their housing situation. We've advised over 250,000 renter households since we opened. And all our services are available in English, Spanish, Somali, and Hmong languages. Just a reminder about our these webinars. We started in approximately mid-April, and we're doing a couple a week, moved it back to weekly, and we've sort of transitioned to start doing the webinars every other week. So we have some guest speakers today, but we'll also, in 2 weeks on Wednesday, the 28th, same time, 1:30 in the afternoon, are going to be joined by a couple more guest speakers that are going to be going through sort of an outline of what types of cases, eviction cases, how many have been filed, some of the reasons that they're getting filed, what's happening in these cases. And so Homeline housing attorney Andrea Palumbo will be joining us, as well as Leah DeGrazia, to share a little bit more about that in 2 weeks. And I will put information about how to sign up for that in the chat. We are applying for continuing legal education credit for both that webinar on the 28th, as well as today's, because we're joined by our friends from Minnesota Legal Aid. So with that, I'm going to pass over to Mike, who's going to just run through Mike Vraw, Homeline's managing attorney and hotline director. He's going to go through just some brief items, just sort of an update, what's happened in the past 2 weeks, and then we'll get started.
Okay, thanks, Eric. Yeah, I'm just going to touch on the current, as I've been calling them, hurdles that a landlord would have to clear in order to be able to file an eviction here in Minnesota that we've talked about since April, and update people on the status of those. So the first headline in that regard is the Minnesota moratorium, which is we've talked about since April. This is the first hurdle a landlord has to get past. The state moratorium on evictions is tied to the peacetime emergency declaration, at least in time. And that was renewed once again on Monday of this week, and it will run through November 12th earlier this year. It's been renewed by the governor 7 times already. The legislature has voted on whether to not end it. That's kind of how it is phrased, I suppose, several times. And each time the Senate, controlled by Republicans, has voted to end the peacetime emergency. The House, controlled by the Democrats, has not voted to end the peacetime emergency. The governor, of course, being a Democrat, is the one declaring the peacetime emergency. And unless and until both chambers of the Minnesota legislature vote to end the peacetime emergency, we will still have the peacetime emergency in place. And as mentioned, the eviction moratorium is tied to that. I suppose the governor could issue a new executive order ending the eviction moratorium. We've seen no indication that that would happen. And so that is hurdle number 1 that a landlord would have to get past in order to file an eviction in Minnesota for non-payment of rent. There are some exceptions, and I know that our guests today are going to be talking about some of those exceptions, so I don't want to jump into that too much. But the other thing I should mention is a second hurdle that a landlord would have to get past in order to file an eviction for non-payment of rent in Minnesota, which, once again, is the primary reason that landlords file evictions in Minnesota. Well over 90% of normal evictions in a normal year are for that reason. So if a landlord wants to file an eviction for non-payment of rent in Minnesota and the governor's moratorium gets lifted, the executive order gets lifted, let's say on November 12th, The landlord still might not be able to file an eviction because the Center for Disease Control, the CDC order, federal order, essentially bars evictions for non-payment of rent through the end of December of this year. Now, a tenant has to take some steps in order to fit under the CDC order, but they're not that complicated. They're pretty followable. So in large part, a landlord would not be able to file an eviction, most likely against most Minnesota tenants until the end of December. Now that could change. There could be a new federal order, I suppose. But as it sits right now, it looks like for almost all evictions in Minnesota, landlords really effectively can't file evictions until January 1 of next year. There are exceptions. Again, that's what our guests are going to be talking about here in a moment. But those are the two main hurdles that we should all be aware of going forward with eviction moratoriums in place both at the state and federal level. Okay, I think that was, is there another? Nope, no, we're ready for Luke and Mary. And Mary, I'm not sure I've ever heard your last name said out loud. Could you say that for me?
I kind of want to make you try just because.
Wow, that's neat. That's a really nice thing to do to somebody. I'm gonna go, all right.
No, I'm just joking.
Kazorik.
Really close. It's
No, it
Kachorik.
wasn't.
No, I
Kachorik.
mean, it's the most common way it's mispronounced. So take that. No, it's Mary Kachorik.
Okay, Mary Kachorik. Okay. Mary and Luke both work at Minnesota Legal Aid. Are you guys in the same physical office pre-COVID? Is that where you're at?
Yep, we're both in
Okay.
Minneapolis.
Yeah, and I'll let them take it over here. They're going to talk about evictions, and I'm going to be helping moderate questions that come from the audience, both ones that were submitted in advance, along with ones that you can submit live throughout the webinar. We have the Q&A and the chat boxes available. Those are the best ways to send us a question. So I'll turn it over to you guys and hit mute on my end.
Awesome. Well, thanks, Mike. And yeah, I mean, thanks to Homeline for having us and hosting us. Just a quick word about that. I love the partnership that the legal services organizations across the state have with Homeline. You know, Homeline is still the first place to call for most tenants who are having questions about their tenancies, and that's statewide. I think where legal services comes in is we're oftentimes the ones who go to court. And so Homeline has been doing a great job getting us cases by sending out letters, referring folks to us at the point their case is going to court. But in terms of giving the advice, becoming the experts on the moratorium and really having eyes on how people are being affected by evictions, even now, even during a state of when we say there's a moratorium in place. You know, Homeline's been a great partner in that, and hopefully we'll be able to make some changes at the legislature. And so it's been fun working with Homeline, and thanks for having us.
Thank you, Luke, and we're grateful that both of you are here.
Yeah. So for those of you who don't know Legal Aid, Mid-Minnesota Legal Aid, we're one of a number of different legal aid organizations. Legal Aid covers the whole state. Really, there's a legal services organization that covers every square foot of the United States in one shape or form or another. And our service area is about the middle third of the state of Minnesota. Starting in downtown Minneapolis is where Mary and I both work, and we primarily serve Hennepin County. And what we'll talk about today is primarily evictions that are being filed in Hennepin County, mostly because that's what we're most familiar with. Our lawyers who are based in St. Cloud and Wilmer ask questions, and some of the case examples that we'll provide are cases that are being filed across the state as well. But again, our view of this is, you know, cases where it's in court, a person is facing eviction. We get calls about from people who are facing self-help evictions, lockouts as we call them. That continues to happen. It's definitely happening at a faster pace. I know the Attorney General's office has been great about intervening in those cases. Our rate of filing lockout petitions, which is an emergency court action to get back into property, that has certainly gone up too. But the context of what we want to talk about today are the evictions that actually get filed and how things are going on in court. We'd love it if you ask questions. Mary and I will interrupt each other because that's what we do, and it's more fun that way. But I hope you all out there can feel comfortable interrupting us too. It's more fun to answer questions as they come up. But that's the framework for our talk, and it's a little bit about who we are. There's, I should say too, we have a number of colleagues in our housing team now. There's 17 lawyers in our downtown office who do some housing work, some eviction defense work. They're all great lawyers, and a lot of these cases are theirs that we'll talk about. Mary and I are oftentimes just passing on the good news about work done by others. So we'll try to do that in fairness to them. And another thing quickly about that is we talk about case examples or types of cases. We're drawing from our experience on real cases. We're not going to use, specific case names. Typically, if we win a case or settle a case, which is most of the time, we get the case expunged. We try to make sure that there's no eviction on a person's record when it's all over with. And occasionally that's not true, but we can't keep track of which ones it's true and which ones it's not. So we'll just sort of talk generally about cases and about trends and things we're seeing. And some of them are amalgamations of different cases that have come through, and some are very specific examples, but we've changed the names to protect the innocent. But,
And Luke, if I could jump in for 1 second.
sure.
I've gotten these comments from landlords over the years. By the way, we're being watched by landlords, social workers, tenants. A wide group of people are interested in what we have to say today.
Sure.
And one of the things that I'm asked frequently by a landlord, if we're involved in a case, is, well, the tenant gets a free lawyer, and that's unfair. And how is it that you can decide on the cases that you take? And one of the things I almost always tell landlords is that we're not public defenders, just like you aren't. A public defender, every criminal defendant is guaranteed representation. When do you decide, not eligibility, not income eligibility, but when do you decide to actually work on a case as legal aid? What kind of motivation or requirements do you have?
That's a great question. And the American judicial system, not to go too far down that rabbit hole, but it's based on the idea that both sides will have lawyers. And you can see that if you go to an eviction court hearing, an eviction trial, you can see that having a lawyer makes a huge difference. And so I know that maybe there are some members of the landlord bar out there. By and large, landlords are represented now, the vast majority, particularly I think in the situation we're in now, where you have to meet these exceptions in order to get your eviction heard. The representation rate, I'm not sure if that's something that maybe you guys are tracking, Mike, but just anecdotally, it seems like there's very few pro se landlord cases that we deal with now. Almost all of our landlords are represented, which is most of the time great. There's really good lawyers out there who represent landlords, and that. But so there's great lawyers representing landlords. There needs to be lawyers on the other side in order for the judicial system to come to the right answer. It's maybe an unfortunate aspect, or however you want to look at it, but that's the way our system is built, that the judge is an impartial audience, and they will not be looking for defenses that tenants can raise. They need to raise them themselves. And we'll get into it a little bit, but there's just a huge number of laws that protect tenants that no one would know about unless they not only went to law school, but they happen to have studied and worked in these areas for a long time. There's nothing on the face of an eviction paper that you get served with that says you might have rights under the Violence Against Women Act and the Fair Housing Act and the other 59 some odd laws that apply to eviction cases that are potential defenses for tenants. So what I'll say to that, and this is a very long way of getting to your question, Mike, we evaluate cases for merit, but we're also not just taking slam dunk cases either. We're taking cases where there's a factual dispute, where there's a law that we think protects the tenant. We don't win every time, but as I said, we either win or settle most cases. We're very willing and open to settling cases when it seems like that's the best outcome for the tenant. We help tenants get better settlements so that they don't have evictions following them around, being that scarlet letter on them, on their credit records, so that it's impossible to find housing in the future. So, but we don't take cases that we know are going to be losers. As you said, we're not public defenders. We're not required to take cases. So we assess for merit before we decide what to do with a case. And that actually was one thing I wanted. There's about 30 cases being filed in Hennepin County a month right now. So roughly like one a day is kind of an average. And those are cases that the court has deemed meet at least one of the eviction moratorium exceptions. That's roughly the rate. We take a look at about 6 to 10 cases per week of those. So that would, in theory, be almost every case that gets filed. But we don't actually take all of those to court. We're representing on between 3 and 5 cases per week in Hennepin County. So that, I mean, that's just a rough sense. I mean, we're touching a lot of the cases that get filed in Hennepin County right now, but we're not taking all of them to court. Not every case goes to trial.
Thanks, Luke.
Yeah.
May I interrupt? As
Of course.
promised.
Yeah.
Something else I'd like to just add briefly about Mid-Minnesota Legal Aid is that we have a variety of practice areas. So we're in housing, but we also have lawyers who work in disability law, public benefits, immigration, youth law, seniors law. And so for landlords out there or folks who are looking for help with other kinds of legal issues that affect people who are low income, people who are seniors, or people with disabilities, know that legal aid has all different kinds of practice areas, and we welcome those kinds of intakes as well.
Great. And so I'm not sure if you guys have seen the show or not, but when you want to turn the slide over, Eric he's the guy in charge of it. So let him know.
Okay. Yeah, I think we can move forward, Eric, whenever you're ready. So we just, roughly speaking, I mean, we're going to categorize a little bit because I'm assuming we have an educated audience, and that Mike has talked to before. You know, there are these exceptions to the eviction moratorium. We kind of group them in cases involving crimes, cases involving breach of lease, and cases involving holdover. And each of those have been narrowed, and that's what we're going to get into, but those are the 3 basic categories. Go ahead, Eric. So the first category I'll take and then pass over to Mary, but case involving unlawful activity on the property. And this all comes under the same statute, 504B.171. I'd say this is probably as a category, the cases that we're seeing the most of. Some of the exceptions to the moratorium just went into effect in August, and where the exceptions under 504B.171 have been in place since the eviction moratorium first was created back in March. So that explains to some extent why this is the biggest category that we see, and that might change. We've certainly seen more other types of cases, but the statute itself lays out the different categories of crimes or unlawful activities that potentially could lead to a case. And they're there in front of you: drugs, guns, prostitution, and stolen property. Go ahead, Eric. There's a couple limitations to know about if you're facing an eviction under this statute, if you're representing somebody. And the first is that we're not talking about unlawful activity anywhere in the universe. We're talking about alleged unlawful activity that has to have taken place on the property, or, and it's one of those fun law school words, the curtilage of the property. And that's right from the statute. It just basically means in the area around the property. And if anyone ever knows exactly where the curtilage begins and ends, maybe they could tell me. But so the point being that we're not talking about crimes that took place across town or allegations about crimes that may or have happened in other places. We're talking about alleged unlawful activity on the property. Go ahead, Eric. And then another thing, it says that we'll talk about this in a moment, but in order to be evicted for breaching a lease, there has to actually be a lease, a written lease that has provisions that you had to have violated. That's not true under this statute, though. The statute itself basically says that the promises not to engage in these unlawful activities are implied into every lease, whether in writing or parole meaning oral or verbal. So really, the thing to know is that a person can be evicted under this statute regardless of whether there's a written lease or not.
And Luke, I just jump in for a couple of things. First of all, 504B is the chapter where we can find Minnesota landlord-tenant law, most of it. That's where you'll see most of the statutes. There's a lot of cases and a couple other statutes that matter as well. But this was the law before COVID-19. 504B.171 didn't get created because of COVID-19. It's just one of the exceptions noted by the governor since the moratorium started.
That's absolutely correct. And thanks, Mike, for helping me helping us keep in mind, the framework and realizing that not everyone here is an attorney. Absolutely, yes. So these are cases we saw before, but we don't see that many of them. We didn't see that many of them pre-COVID. There's a huge. It's partially because we're not seeing non-payment of rent cases. We're more likely to see these. But one of the lessons from all this is that there might be cases being filed that never have been filed before. Landlords are searching for reasons to evict tenants and using statutes like this one, 504B.171, in contexts where they would not have before. Go ahead, Eric. Another limitation of the statute that's important, there's an innocent tenant defense, is sometimes what it's called. Each of those categories of unlawful activity is started by the word allow. The tenant shall not allow illegal guns on the property. The tenant shall not allow drugs or drug manufacture to be on the property, or prostitution or stolen property on the property. The word allow, the definition of the word allow means to give permission to do something. What we'll see a lot of is cases where someone may have done something bad on the property. They may have even broken a law or committed a crime. But there are definitely cases where landlords file the eviction saying that the tenant did those wrong things or bad things, and it's not true. Someone maybe loosely affiliated with the tenant may have done something wrong, or there's a lot of cases of completely mistaken identity where the tenant is facing an eviction for something that they really had no control over the person at all, and that person really had no connection with the tenant. But it also comes up in situations like domestic violence. A tenant might have, there may have been a crime committed on the property that our client, the tenant, is actually the victim of that crime or that unlawful activity. And that tenant, our client, did not allow that conduct to take place. So if we're talking about guns, drugs, and it's guns and drugs that were brought on the property without our client's permission, without their knowledge, and in our view of the law is that they are then not responsible for those actions under the statute.
And Luke, I'm going to ask a question that just came in from Emma that's right on what you're talking about. A question that we've gotten many times over the times that we've done these presentations, but it's worth asking because we have different people join us for each one of these sessions. So with regards to the criminal activity exceptions, does the tenant need to actually be convicted? So a criminal conviction, or can they be evicted based on allegations? What proof is needed?
It's a very good question. I can't remember if we have a slide on it or not, honestly, so we'll just answer it now since Emma's asking it now. But yes, it's absolutely, it's a big problem with the cases that under this statute, alleged unlawful activity, is that there's no evidence. There's just no evidence in support of the allegation. So an eviction complaint can say that a person committed a crime or a tenant committed a crime, but there's no evidence that it actually took place. So there's no conviction. Sometimes there's a police report, but the police report is completely filled with hearsay. There's no proof that anything actually took place. There's no actual evidence at all. But to answer the question directly, there doesn't need to be. A landlord doesn't actually have to walk into court with a conviction in order to get someone evicted. And the standard of proof in a civil case is lower than it is for a criminal case. So a prosecutor might choose not to prosecute a crime because they don't think they can meet the standard in criminal cases, which is beyond a reasonable doubt. It's a high standard, high burden. Or it might be just because prosecutors are busy. But if the landlord can go to civil court in an eviction context and convince the judge, the jury, the referee that the tenant committed an offense or committed one of these acts, if they can convince them beyond a preponderance of the evidence, a much lower standard, which really just means more likely than not, they can do that. They can still win the eviction case, even though no crime was ever charged and there was no conviction at all.
Okay, so no conviction required. It would help the landlord, clearly.
Yes.
You mentioned a police report. If you were a landlord lawyer, would you feel like you need to bring that police officer into court to testify to win that case, or is a police report going to be sufficient?
That's a really good question that we frequently get involved with in court. There's a hearsay exception that specifically applies to police reports in Minnesota, and it's not for those of you who are remembering your evidence classes from law school, there's no analogous rule in federal court. It's changed and it's different in state court. And landlord attorneys could read it to say that police reports can get into evidence. It specifically says that reports made by a duty as authorized under law, that includes observations that were made by a duty under law, including in a civil case. It excludes police reports from criminal cases, but allows them effectively in civil cases. The nuance, though, is that it does not say that anything written in a police report can come in. So that hearsay exception effectively allows the police report itself to come into evidence. But police reports are oftentimes chock full of speculation and hearsay within hearsay. And that exception does not allow a landlord attorney to introduce a lot of hearsay within hearsay. You know, the police officer shows up and is told by bystanders or other people, like, he ran that way, he ran into her apartment. You know, that's the kind of thing. He ran into her apartment. Well, that statement is hearsay itself. It's not really proof of anything, and that statement should get excluded as hearsay, even if the report itself comes in. So yes, police officers should be required to come to court, and oftentimes they are. I mean, to give the landlord bar some credit, if they know what they're doing, they'll bring the police officer to court, and it's just a question of what that officer actually has to say and whether they can actually give the evidence that's required to win the case.
So if I can boil down what you just said about the hearsay within hearsay kind of thing, the police officer writes in the report, as the police officer, I smelled marijuana in the hallway. That would probably be admissible. But if the police officer wrote down, a neighbor reported smelling marijuana in the hallway, that would be the hearsay within the hearsay problem that you were just talking about. Does that sum it up?
Absolutely.
Okay.
Yes. Yeah. Thanks, Mike. Okay, go ahead, Eric. I'll keep moving here a little bit. I'll turn it over to Mary to talk about breach cases then.
I saw another question about verbal threats from a resident to a landlord. And I think what I'll do is kind of go through this and then we can use that as an example. But certainly feel free to ask other questions. So the other kind of second category of cases that can get through in the current eviction moratorium, that's the state one, is for breach of lease cases. So, and I should say a certain subset of breach of lease cases. So to have that, the first thing that you need is a lease to breach. It has to be a written lease. It has to have what's called right of reentry clause that basically says that if the tenant breaks this term of the lease, the landlord has the right to come in and get the property back. And not only must there be a written lease with a right of reentry clause, it must be a material breach. So it can't just be a minor thing or a not important thing. It has to be material, which means important and significant. And there's probably a dictionary definition one could pull up that elaborates on that further, but essentially it has to be a serious, important violation of a written lease. If you want to go to the next slide, please. So we're in material breach land, and our favorite word, curtilage, comes up again. And now we're getting into the language in the eviction moratorium itself. So pre-COVID, pre-eviction moratorium, a landlord can bring a breach of lease case. And everything that was on the last slide would be true at any time. And now we're entering into the kind of subcategory of things that a landlord can evict a tenant over right now under the current moratorium and the exceptions. So here it has material breach or material violation, I think. Let me pull up the order itself. Yep, so it's materially violates a residential lease by the following actions on the premises, including the common area and the curtilage of the premises. So this is the same thing that Luke was saying before, where it's either on the property, so in the apartment or in the home itself, or on the curtilage, which is again just a legal word for the area kind of immediately surrounding that property. And the two types of cases that can come in now, and Luke made this slide and the arrows are like pretty lame. So I don't know if you can tell that the on property or curtilage is like in the middle, and then significant property or seriously endangers are like both subsets of that. Because it kind of looks like a lopsided flowchart right now. Sorry to throw so much shade on your PowerPoint slide. Anyway, so we're in
PowerPoint
I
material.
thought you were a
not
graphic designer, Luke. What's going on?
Yeah, clearly
I missed
not.
that course in law school.
At least I haven't spelled any major words wrong, at least that I've seen. That'll probably
We'll
come up.
see. We'll see how it goes. But anyway, so we are in material breach of a written lease on the property or in the curtilage. And then there are kind of two buckets that that a landlord can use right now. The first is significant property damage, or the executive order says significantly damages property. So we would read that to mean, and I think a referee would also read it this way, that it can't be property damage from like 10 years ago, right? It has to be, it's written in the active voice, so it has to be property damage that's occurring now. And the other bucket would be seriously endangers the safety of others. And that doesn't necessarily mean other residents. It doesn't mean property managers. It can mean anybody. So it's not limited. It's the safety of others, anybody. And that's also written in the active voice now. So it can't be something you did 10 years ago that we're going to try to evict you over now. It has to be something that happens now that seriously endangers the safety of others. And I don't recall if there's another slide. Eric, do you want to? Okay, so do you mind going back and I can address the question? I should really pull up the slides before I tell you to move forward. Okay, so someone had a question. There is an assistant director of a property. Would verbal threats from a resident to a landlord or office staff be eligible for eviction during the executive order? So the only way that that could come in and be heard by a court right now would be under this second category of a material lease violation or a material breach that would seriously endanger the safety of others. So to get there, there needs to be a written lease that has a right of reentry clause. There needs to be language in the lease that would make that kind of conduct a material breach or a breach. The verbal threats would have to be material or serious enough or significant enough to meet that material or materiality standard. And then it would have to seriously endanger the safety of others. So like a lawyer, I'm going to say it depends. That's kind of a fact intensive or case by case analysis. So if there's a very clear language in the lease, there's a pretty clear concrete threat to safety, I can see a world where that would be a serious endangerment that would get someone into court under the executive order. On the other hand, if someone makes kind of an offhand comment or there isn't a written lease, I can see there being a good case for that not being considered within this exception to the eviction moratorium now.
Mary, can you just give us kind of a concrete example of what you think a threat would be that's sufficient to trigger this order, and then one that you don't think would be enough?
Okay, for the purposes of illustration, I'll be a little extreme. I'm not going to swear, don't worry. So something like, I'm going to kill you tomorrow. You know, like that's one end of the spectrum, right? Where it's really specific, it's really direct, there's a timeline. Like that I think could be, now don't quote me on this because I don't want to get the I'm going to kill you tomorrow case and have to argue against myself in court. But I think something like in kind of on that end of the spectrum where it's just someone is legitimately very afraid of their safety, I can see that. I can see a referee finding that being serious endangerment. I think on the other end of the spectrum, you have something like, oh, I really hate her, or something like that, where it's, or maybe that's even too lame. I don't know, Luke, do you have a good one that would be
We actually,
verbal
this
threat?
is
Or
such a,
yeah, go ahead. Sorry.
no, I was going to say this is such a common question or common set of facts that it's in one of our later slides about kind of like common example cases that we're seeing. And I was trying to just think and look through some notes about like all the different iterations of that fact pattern we've seen, because we've seen a ton. And yeah, I mean, you know, threatening behavior sometimes is just, and you know, it's so hard for us to evaluate this. Now, this is jumping ahead a little bit to those examples, but all we hear sometimes, or our lawyers hear, is, well, I didn't do it. I didn't, you know, it becomes a he said, she said, or a she said, where the manager, the eviction complaint says, she told me she was going to kill me. She was going to kill me and kill my whole family or something like that. Or, and, you know, usually swear words are included. And Mary won't use them here. But then we talk to the client. She says, no, I never said that. It never happened. And so there gets to be like perceptions and issues about like, you know, two ships passing in the night. And then we want to be aware that property managers out there have very difficult jobs sometimes. I'm sure there's some people on here who are property managers, and we don't want to start from the assumption that their assessment of the situation isn't true, or that it isn't valid, that they really were afraid in that moment. They absolutely were. But it becomes very difficult because we don't know what happened. The judge doesn't know what happened. And that's why we have a court process, is to try to figure out what happened.
So there's likely going to be proof issues, is what you're saying, unless it's
Absolutely.
emailed or texted or something like that, at which point the
Yes.
landlord would have a better argument. Mary, I wanted to point out one thing that you've mentioned a couple of times now. You've mentioned referees, which exist when it comes to evictions in Hennepin and Ramsey County. Through the rest of the state, we have people watching all around the state. There are no specific housing courts. It's judges, district court judges that hear these cases. So it's referees or judges. I realize you're trying to be direct, but I assume that's kind of how you mean it, referee or judge, right?
Yep.
Okay.
Exactly. I see a couple more questions. Do you want me to look at those, or do we want to keep going? I kind of defer to you guys. You're muted.
I'm sorry. I'll jump in whenever I think they're right on point. Otherwise,
Okay.
we'll try to get through your stuff, and then we'll start taking questions just at length. Because you're right, they
Okay.
are flowing in right now.
All right. All right. I think that's enough for this slide. Luke, do you want to do holdover?
Sure. Yep, absolutely. Okay, so holdover is a legal term of art we use to really just say a person who's staying after their lease or their tenancy has ended. So holdover as in like I'm holding over, staying too long. So, and that's pre-COVID. I mean, this is a longstanding basis to evict somebody. They were supposed to move and they didn't. It comes down to that. So even pre-COVID, there's a concept that there has to be an actual legal end to the tenancy. And one area of confusion we're seeing, I think, particularly from landlords and landlord attorneys sometimes, is this, because there's this new exception that we'll talk about in a minute, but it's the need to move an owner or a family member into the property, that then they can skip over the step of actually terminating the tenancy. And that's not the case. They still have to go through the proper steps. And those steps have to be followed under what courts have said in Minnesota. They have to be followed with strict compliance. If the lease says there needs to be 60-day notice or 55-day notice or 2-month notice, they have to follow the lease. Even if there's no lease at all, it's a verbal tenancy. They have to give at least one full calendar month notice. It has to be in writing. It has to specify the exact day that the tenancy ends, and that has to be given to the tenant. And all that has to happen in before the tenancy is terminated. So, but the next step after that, why we're not seeing a whole bunch of those cases being filed, the only type of holdover case that can go forward now is this family member exception, or what the executive order says is that there's a need to move an owner or a family member into the property, and that the person has to move in within 7 days after the person vacates. It's by far, I think, led to the most confusion. And the Homeline, I know you folks, you get the most questions about these things coming into the hotline. So you may see it even more than we do. And there's a ton of interpretation problems with it and fact issues with it, and we have this as sort of a case example later on, but there's just a lot of case situations where the landlord has been fighting or trying to get a tenant out for months, wanting to get the tenant out, and then all of a sudden says one day, my sister needs to move in, or my cousin wants to move in, or my nephew is going to move in. And it becomes it's a very suspicious act. It might be true, it might not be true, but certainly from the tenant's perspective, they say, you're just mad at me because I've been complaining about the repair problems and asking you to fix things. And now all of a sudden, and you can't evict me and you can't terminate my lease under normal situations. But now there's this exception for family members. So this family member kind of appeared out of nowhere. So that's the situation that we see a lot. It's not true all the time, but this is what it says.
Actually, a question we just got: do cousins count as family members?
I believe what it says is close family member, and I don't know that anyone has defined that, what that means exactly. So your guess, questioner, is as good as mine. I don't know that we've
No,
got.
it doesn't even say close. It just says the owner or the property owner's family member.
Okay, for some reason, all right. Yeah, it's unfortunate. I think it's, and I know Homeline had some, like, we all, once this new language came out in this executive order 20-79, we all immediately, I think people went right to this one as like as a big area of concern, because it's just, there's too many areas to be interpreted. And we don't have the answers for you today in terms of how judges are interpreting them. We have some case examples, but up until now, the cases have been largely dismissed, or we've been successful by attacking the failure to give proper notice. And so that step on this slide that you can see, there's too many landlord and landlord attorneys trying to skip over that first step and just going right to the eviction stage, or without having actually terminated the lease. So to my knowledge, I don't know that there's been like a detailed factual case that's drilled into some of these things where we could tell you, like, well, this judge is saying this and this judge is saying that. And that makes sense. This became effective in August. So at the minimum time frame, we could be starting to see eviction cases now. The landlord would have to give a notice in August to terminate the tenancy at the end of September. And then right around now, there might be some cases that'll get heard and decided within the next few weeks. Hopefully, I mean, ideally, there wouldn't be case law on this exception before now, if judges are properly applying the rule that the tenancy actually needs to be terminated. Did you have a question, Mike, or anything on this before we?
No, I was just going to kind of echo that lawyers rely on precedents. And in the last 6 months, that's not really what we're doing. We're theorizing what laws may or may not mean a lot of the time. And the one that you mentioned, 20-79, there's another question about that. Who checks up on the landlord to make sure that they actually did move in, that their family member moved in? These are all valid questions to ask about that. Is a cousin count as a family member when it could have been defined? There are plenty of exceptions or examples throughout the law where family members are literally defined by law, and sometimes a cousin would apply, sometimes it wouldn't. So it could have been there, it just isn't. And so, yeah, to say what a judge will do is really hard for a lawyer to assert with any kind of authority right now.
I was going to add one other thing too, is, you know, we're kind of, you all are speaking in terms of what's happening in court, but, you know, we definitely are hearing these types of instances, and landlords alleging that they're going to use one of these, even though that they're maybe not giving the proper notice and all those types of things. And I can't remember if anybody's touched on it yet today. I'll put the information in the chat. You know, the Minnesota Attorney General's office is who you can go to. They have an eviction complaint form in multiple languages on their website, and they have a toll-free number for throughout the state. So I'll put that in the chat again, just as a reminder that if you do see one of these instances, some of this might be happening outside of court, right? And so, yeah.
One last question on this topic, which is, did the governor's office talk to anybody, like at Homeline or Legal Aid, about the family member exception before they passed that order? And I can say with great authority that nobody at Homeline was consulted about this. I'm not sure about Legal Aid, but
No, not about that specific language. And
yeah,
I'll say for the governor's office, they've been willing to hear some criticism, but on the other hand, it hasn't really changed or been amended either. So we're dealing with what we're dealing with.
Yeah, the governor's got a tough job. There's no way everybody's happy.
Right. Totally.
These days, yeah.
One thing, just to echo what Eric just said about the Attorney General's office, and we're doing this too. When clients call us and say, I got this notice about this family member, but there's no eviction yet, then there are some steps that we can take to investigate that. And I know anecdotally that the Attorney General's office attorneys are doing the same thing, which is we can explore it. We can say, who is this family member? Give me their phone number. I'm going to call them. I'm going to figure out, you know, where they were living. And I know the Attorney General's office is following that and using some of their access to databases and other things so that there's a little bit that can be done. I mean, if they just say, you know, well, my sister's been sleeping in my basement for the last 10 years and now all of a sudden decided to move into this rental property or whatever, then there's a limit to what they can do. But if there really is in fact a family member who's otherwise doesn't have a place to live or needs a place to move, I mean, there is a little bit of investigation that can be done, but it ultimately does get to a point where it's so hard to prove that it's just leading to a lot of unfortunate confusion. So.
And the AG's office, just so we're clear, has a supersized role in landlord-tenant world this year with COVID-19. They didn't used to have this kind of activity, but they are named in these executive orders as the entity tasked with making sure that landlords aren't evicting when they're not supposed to. So us mentioning the Attorney General's office isn't our office or legal aid just trying to pass off work. The AG's office is, in many cases, the only place that can enforce these rules.
Okay, here's a slide for you.
Can I take this one?
Absolutely.
So we're seeing a bunch of cases like this where there's a kind of a vague allegation, sometimes more than a smell. Sometimes there's like a plume of smoke alleged to have been seen. But basically, what we're getting at with this slide is there are landlords and property managers who are thinking that there might be some marijuana or drug use at the property, but they didn't really see it, and the cops didn't come, and there isn't a police report. And the statute is really specific, right? So if you think about the language in the law that Luke talked about earlier, 171, it talks about manufacturing, selling, giving away, bartering, delivering, exchanging, etc., controlled substance. And this also goes to the allow language, right? So we had a case recently where there was a fourplex and someone smelled something that was either marijuana, tobacco, or hemp smoke coming from what they thought was probably the direction of a tenant's unit, and tried to evict the tenant under the exception for the covenants in 504B171. And what it came down to is they just couldn't prove their case. So like Luke talked about, the standard is more likely true than not in civil court for an eviction case. For a landlord to win, they have to prove to the referee, the judge, the jury that something is more likely true than not true. And they have to provide evidence of the claims that they're making. So that evidence can come in the form of testimony, but there's a rule against hearsay, so it can't be, oh, so-and-so told me that they smelled marijuana on this day. It has to be firsthand testimony. It could be photos, it could be documents, it could be police reports, other witnesses providing testimony. But what I'm getting at is a landlord still has to prove their case. So even though there are these exceptions under the current executive order, a vague allegation of smelling something like marijuana or smelling marijuana isn't going to be enough to evict a tenant. They still need to prove it. And what we're seeing is a trend of landlords or landlord attorneys filing these cases, these like smell cases, without more details in the complaint about when it happened, who was there, what drug it was. And it's, from where we sit as tenant advocates, it's kind of alarming. And the court is being liberal in hearing these cases, right? So the court is only letting cases come through that fall into one of those exceptions in the order. And so if what we're seeing in Hennepin County anyway, and I'm not sure what's happening in greater Minnesota or in the other metro counties, is if it's alleged, the referees are pretty much letting it in, even if the complaint is pretty bare bones about the details of what was alleged to have happened. So, you know, for the tenants out there and the tenant advocates on the webinar, I would just encourage you to, you know, or just remind you that the landlord still has to prove their case. And for the landlords out there, I would encourage you to remember that you have to prove the case, right? Just having a neighbor or someone think that they smelled something, that's not going to be enough to evict someone in court. And what would be really unfortunate is if this was being used as pretext for trying to evict someone for not paying rent, for complaining, for retaliation. You know, it can be a way to get at evicting someone that a landlord might want to evict for a different reason. So I'm not sure if there's more to add about that, Luke, or if there's other things you wanted to touch on, but that's what we wanted to cover with that example.
Yeah, so this one, we obviously already kind of talked about it, but it's just another very common like set of allegations, and another one that it really depends on the context, but we kind of covered it before. The one thing I wanted to say about this one is to remember that there is a defense to an eviction under the Fair Housing Act. So sometimes aggressive behavior by a tenant, or what's perceived as aggressive behavior by a tenant, by a property manager, can be the result of a person's disability. And in particular, it's a person's mental illness that can sometimes cause that. So if a tenant's engaged in threatening behavior at the property, oftentimes, and they might even say, Mary was thinking earlier about how bad does the threat need to be? The threat can be pretty bad, but if it's a result of that person's mental health or mental illness, then the tenant potentially could have a defense under the Fair Housing Act. Now, this is very controversial. I know that. A lot of landlords and property managers really don't like this, but it is the law that a tenant is entitled, a person with a disability is entitled to seek a reasonable accommodation for that disability. And there are some pretty compelling cases that we could give you examples of where there was a threat alleged against a person. And when we investigated, the person suffered from schizoaffective disorder, had been, because of COVID, and this was early in COVID, had been unable to get the prescription medication that he needed and had an outburst. And this is a person who's never once been convicted or even charged with any kind of assault or any kind of crime involving violence. He's not a violent person. He had a violent episode that was a direct result of him not being on his medication. Well, that's not a situation where a person needs to be evicted. It potentially could fall under the exception. It could be a breach of the lease. It could go through all those steps that Mary mentioned. But I just want to make sure that people understand out there that there is the Fair Housing Act, and that can potentially provide defenses in these circumstances. Go ahead, Eric. So Mary and I can kind of toss this one back and forth maybe. Each of these is sort of a common set of facts, but it also sort of triggers a specific defense. And the one here is the Violence Against Women Act and other related laws that we have in Minnesota at the state level that protect survivors of domestic violence. So there's allegations about noise, about swearing, about things breaking. And then when an eviction gets filed, it's a breach of lease. Tenants are concerned. Sometimes it's the abuser who's committed the conduct that falls under either 171 or a breach of lease. But this is kind of the bare bones of it. Is like when we drill into the case, there's screaming, there's shouting, there's police calls, there's that kind of thing going on. But there are defenses to that. There's a state law that says that a person cannot be evicted for calling the police. And that's oftentimes what, at least part of the allegations. And then there's the Violence Against Women Act, which does not apply to all tenancies, but it applies to subsidized tenancies with Section 8 vouchers, public housing. That says that if it's the direct result of domestic violence, that a person cannot be evicted for conduct that's the direct result of domestic violence. We have a domestic violence expert who comes to court, and she'll testify that even sometimes conduct that's committed by the survivor of violence, that is often explained by a long series of abuse that's committed by another person, and how that affects a person's brain can sometimes lead to acts that otherwise would be breaches of the lease. And just like in the reasonable accommodation context, one thing I want to stress with this, knowing that there's kind of both sides out there, is is that these are sometimes situations where there can be a long-term solution put in place. With the reasonable accommodation, it's getting the person back on the medication that they need. In a domestic violence situation, once we get involved and start representing people, we're going to connect them with their domestic violence advocates. We'll file orders for protection. We'll help break that abusive relationship and stop it from continuing. So there's ways of making sure that this doesn't become like just an untenable situation for the landlord. It just doesn't often get to our attention. No one calls us until there's an eviction filed. And so then that's when we have to respond to it.
And something just to add on what you said, Luke, was just that another option that I don't think folks necessarily know is out there is that we can bifurcate a lease. So we can take an abuser off of a lease, that's something that's possible under that law that Luke was talking about.
And this is actually, I think I was thinking of the same one where there's a door broken, a door kicked in is just like a common scenario. And we see that, and sometimes you'll see that in a complaint. I was looking at a complaint that got filed, and the tenant did not call us, but it was filed just like last week in Hennepin County. And the allegation was that the door was kicked in. And that was the only allegation. And we talked about serious property damage or significant property damage as being an exception under the moratorium for a breach of the lease. Well, the door was kicked in. Immediately, those of us who do these kinds of cases, that's the only allegation, but right away you're thinking, why? Why was the door kicked in? It's not, most of our clients are not kicking in their own doors. There's usually something going on there, and it's oftentimes domestic violence. And this one, I think we kind of already touched on before, but the family member exception and just the fact issues that are inherent in that. And I think we're going to see more and more of those cases. One just quick thing, and then I think we should get over to questions quickly, but I realized we didn't really talk about property damage too much. That's becoming another growing area of cases for us, these significant property damage cases. So when Mary was going through the analysis of breach of lease, one of the changes that went into effect in August in the 20-79 executive order is that a person can be evicted for causing significant property damage. Some of the cases we've seen in that area, though, are disturbing because they come down to what could be a security deposit trial in conciliation court. And there's, and it's so much is in the eye of the beholder. It's another word. The word significant is just really difficult to decide what that means. Is that $500 worth of damage? Is that, what is that? I mean, the case I'm thinking of is one where a mom's 2-year-old got locked in a basement door. And so she did actually kick the door in. That was not domestic violence. And she acknowledged that. She said, I kicked the door in. I had to get my 2-year-old out of there. He was locked in. I had no key for this door. So she kicked it in, and the door is splintered and cracked, and now she's facing eviction along with some other allegations about property damage. But does that really, so maybe that is the tenant's responsibility to pay for that, maybe. But is that something that a person should be evicted for right now in the midst of a pandemic? It doesn't seem to me like that's what the governor had in mind when he wrote the words significant property damage, but it's in the eye of the beholder. And what will a judge or jury or referee say when confronted with pictures of a cracked in half, splintered door? And no one really knows. It's the same problem with the family member exception, is that it's going to be a difficult one to litigate. And it's hard when we advise our clients, because we have to tell them that, well, we could take this to trial and we'll see what the court says. I think we'll win on that particular case. I think we could have won that one, but frequently tenants would rather keep their eviction records clear, and they don't want to fight it. And so they'd rather just settle the case and move, which is really a tragedy in my mind, because the whole idea behind the moratorium is to keep people from having to move and being out there in the community and doubling up or tripling up or living in their cars because they have nowhere else to go. And so some of the exploitations of the moratorium exceptions are, they're things we're going to keep battling against, but but the language of these exceptions makes that difficult and will continue to do so. So there's our contact info, and I think we're ready for questions then.
Okay, well, I think we're going to start with some questions that were submitted in advance, and I'm going to take, honestly, a couple of the easier ones first so we can start eliminating some. But here we are. From Ms. C, are the laws for eviction process the same for all of Minnesota?
Yes, there's a couple small differences. Yes, I'll just say, yes, they're the same. The process is the same for all of Minnesota. The way each court handles evictions is different on a district level. And so we talked about referees and so forth, but I don't think we need to drill into some of those fine details at this point. The bottom line is that there's a state statute that covers most of the processes that govern evictions.
And I wasn't trying to trick you with the question, though. It's an honest question somebody sent in. It's a fair question, though. They might think that there's different rules for the city, and that's true in some parts of the United States where the city will have different rules in the state. From Jessica, are landlords allowed to charge a late fee during the moratorium?
I would say yes, as long as it follows the law for late fees and as long as the landlord doesn't try to evict a tenant for not paying a late fee. Our position at Legal Aid is that a late fee is not rent and is not something that you can be evicted over under the non-payment of rent statute. And there's a law in Minnesota that says that a late fee can only be 8% of the overdue rent amount. So because there's a pause on non-payment evictions right now, I think a person can't be evicted for that, but I think a landlord can still add that to a rent ledger if the rent is late for a month.
Yeah, so late fees are, I think, really among the most confusing topics, COVID-19 era, because there's been different rules at different times from different sources. So the state has never banned late fees. The CDC order, the current federal CDC order, doesn't ban late fees, but the CARES Act did ban late fees through the end of July, but only for properties that were covered by the CARES Act. And so people have heard that. And so what we saw was on August 1, landlords started charging late fees a lot. I think many of them were mistaken in thinking they couldn't charge late fees, that they weren't actually covered by the CARES Act, but they thought, well, maybe we are. We got to just be sure about this. So we've seen since August, landlords much more willing to charge a late fee and feel like they've got some stable footing on that. But I don't fault anybody for asking that question because it's been confusing to follow that as we've gone along. Harriet's asking a question that's kind of a predictive question, but it's on a lot of landlords' minds. When are we allowed to move forward to evict residents for non-payment of rent? When will that actually happen? What do you guys think?
It's super hard to predict, obviously, but for sure not until 2021. Because even if the state moratorium expires, the CDC moratorium will then come into effect and will prevent non-payment evictions until the end of the year. And with respect to all of our landlord friends out there, I hope it lasts longer. And I know that, we don't want to get sidetracked by policy too much here, but there has to be a way for it to be a win-win. We're hearing about only 8 million of the 100 million in rent assistance having been spent so far. That leaves a lot of money left over for landlords to get paid too. There has to be ways of keeping people from not becoming homeless, but also not making landlords take the brunt of the financial impacts of that. And so I really hope there's ways of streamlining those funds so that and other funds become available so that it doesn't mean that landlords have to be impoverished because of the moratorium. Okay,
so here's kind of an issue spotting question. For those of you that are lawyers in law school, you're supposed to spot all the issues that show up in a question, and that's, believe it or not, what real life is more like than not. From Kimberly, I read an article yesterday that said the federal CARES Act eviction law has wording that to avoid eviction, tenant must prove that they've been affected by COVID and they've done due diligence to apply and receive assistance and done everything in their power to pay rent. Does the Minnesota eviction moratorium or the CARES Act take precedence with the eviction moratoriums? I was always led to believe federal law trumps state law.
So I would say that the Minnesota law trumps the federal law. And there's language, I'm a little rusty on the CDC order. I haven't looked at it closely, but I believe that there's language saying that it's a floor, not a ceiling. Wait, a ceiling, not a floor. Whatever that analogy is, if your state has a more protective version of an eviction moratorium, that controls. So the CDC order doesn't make a state's protections less, it can't take away protections for tenants in a given state. And because our moratorium doesn't have a requirement that a tenant certify that they've done all this work in order to be protected, I would argue that that's not required in Minnesota under the current eviction moratorium right now.
Yeah, one of the other key issues that I was in that question was this was referring to the CARES Act, as if the CARES Act was still controlling somehow. You mentioned the CDC order, Mary. The CARES Act is largely sunsetted as far as its importance goes in landlord-tenant world. So it is the CDC order that we're talking about, and it explicitly defers to a state moratorium if there is a stronger protection in place for renters. So the federal law is clearly secondary to the state moratorium on evictions. That one is kind of a sure answer. Kimberly goes on to ask another question, though, and this is one that is a little bit philosophical, but this is something that we hear almost every time we do one of these presentations, that this really is unfair to landlords to give tenants over 7 months of unpaid rent with no end in sight, and we know eventually we'll struggle to ever recover money from them. How do you respond to that?
I mean, I agree with the general principle that that isn't the result that we want. And I really don't think we have to get into a framework where it's not zero sum, where it's not like one or the other, where it's not eviction versus landlord completely losing their source of income in some cases. And I mean, we've heard it, believe me. I know it might sound like when we're presenting these things that we see this purely from a tenant's perspective. We represent tenants. That's what we do. We defend them in court from evictions, but certainly we can understand. We've heard the stories from landlords who said, "This is my only way of making money. This is my income, and you're taking it away from me." But it can't be. That can't be the end of it. There has to be a way for government to be able to step up more efficiently. And to me, it's a real tragedy that there are a lot of these rent assistance programs that are out there that are going unspent. When we hear stories like that there's 7 months of rent that haven't been spent, and we know, I mean, we know that the individual policymakers behind some of those programs are working hard. They're doing what they can. I don't mean to be too critical, but that's a lot of money that if it could get spent, it can stop it from being a zero sum game, where then the landlord can get the 7 months of rent and the tenant doesn't need to go into a homeless shelter or sleep in a car in the midst of a pandemic while infection rates are still increasing all the time. And there's a huge, I mean, there's a huge racial connection to it too. It's not just that the person who gets evicted is going to have to sleep in their car, but we're seeing how people who are African American are much more likely to become infected, much more likely to die. And in our community, unfortunately, people facing eviction are much more likely to be African American. Our tenants, the folks we represent, are almost 80% people of color in housing court, in eviction court, and almost 60% are African American. And so you can see how if the way the infection numbers are even before an eviction moratorium would get lifted, or if that's the result, how that would have an even greater disproportionate effect, and it would just negatively affect equity in our society. And I say that just because the questioner used the word fairness, and I think there's so many different ways of looking at that. But what I really, really hope is that it becomes some situation where it's not a zero-sum game, where it's not either the tenant wins or the landlord wins, but there's a way that neither has to lose.
And I'm not sure that this really helps explain any of this to a landlord that's upset about this, but I'll frequently hear from a landlord that they can't believe that the governor has this power and the governor is taking advantage of them in this way, at which point I point out that the federal backstop the CDC order has not been issued by the governor. I mean, we've got a Democratic governor, we've got a Republican president that both have a moratorium in place on evictions. So again, that doesn't make landlords feel any happier. They don't get the money in their pockets, but it's not like one specific political persuasion is making this all happen.
Sure.
Lengthy question, and I'm going to try to summarize it from, there have actually been 3 or 4 people named Janelle that have asked questions over this time. So this is a Janelle, and she's concerned about somebody she's referring to as a squatter, holdover tenant, or trespasser. She's upset that the AG's office seems to be saying that they have the rights of a tenant. Can you talk about sort of that threshold? How much or how little it takes to have the rights of a tenant in Minnesota? If somebody was living with somebody else and let's say their boyfriend and the boyfriend left and she stuck around, does she have the rights of a tenant at that point?
I'll take a first stab at this. So what I like to do is start with what the law says. The state landlord tenant law in Minnesota, Chapter 504B, has a definition of what a residential tenant is. And I'll just read it for those of you who aren't as familiar with 504B as us lawyers are. It's a person who is occupying a dwelling in a residential building under lease or contract, whether oral or written, that requires the payment of money or exchange of services. All other regular occupants of that dwelling unit or a resident of a manufactured home park. So we see this question all the time at Legal Aid also, where a landlord is questioning a tenant's right, or maybe a tenant doesn't know what rights they have. Are they protected by the landlord-tenant statute? Are they not? Are they a squatter? Are they a tenant? We also see this come up with folks who are living in hotels. So sometimes someone, especially if they're coming out of shelter or have experienced a period of prolonged homelessness, will end up living in a hotel. And just because it's a hotel doesn't mean that they're not a tenant. There's case law and other parts of Minnesota statute that talk about different factors that a court looks at to decide if someone is considered a tenant and gets the protections in Chapter 504B, or if they are truly a squatter. So the things that we look at are, does the person have anywhere else to live? Like, do they have another place and they're just staying with this friend, or is this truly their home? Where's all their stuff? Is there stuff at this place, or is there stuff at another house or another apartment? How long have they been there? You know, if I helped someone this year who's been in a hotel for 8 months, I think that's a really strong example of, even though it's a hotel, they're a tenant and that's their home. So I think, again, it kind of depends on the facts of the situation, but I think there are a lot of times where even if someone doesn't pay rent, they're protected under this law. If someone doesn't pay rent, the law says that usually, like Luke talked about, the notice period being the period that the rent is due, the interval between the times that rent is due. So if someone pays rent every month, the landlord has to give a month-long notice. The statute has another, in that same part of the statute, if no rent is due, the statute requires that the landlord give that person, that tenant, 3 months, whatever's less. So this is a place where it can get pretty contentious, and folks can feel that it's pretty unfair that someone who doesn't pay rent is considered a tenant. But the way that the laws are written, I think that there are a ton of situations where someone who lives in a place, doesn't have anywhere else to live, is a tenant even if they don't pay rent.
Okay. From Drew, is there anything I can do to gain entry to my house for repairs when the tenant denies access due to COVID concerns?
That's a good question. We've had to advise on that a fair amount, and as I recall, the discussion, at least internally in our office, was divided. And I don't think that there's a 100% answer one way or the other on this one. So as usual, it depends. The law says that a landlord can get access to a property. It allows, as long as there's reasonable notice provided, a landlord is entitled to access. That's what the law says. The question is, what happens if the tenant refuses? I mean, and it sort of gets to the last question too, and just to add on to Mary's point, there are no self-help evictions ever in Minnesota. Like, that is It's not something that anyone wants to see. And I think landlords for the most part as well. So if you're in a situation of wondering, do I use physical force? Then the answer is always no, don't do that. So don't force your way in, don't force a tenant out, don't lock the doors or break the way in. Use the court system. That's why we have it. We have the third fastest eviction process in the country. There's all these exceptions we went through to the moratorium. File an eviction. Don't try to use self-help eviction. So I think the legal question is like, what happens if the tenant says no? You know, in both the lockout situation of self-help eviction and in the circumstance of like, what happens if the tenant just refuses or has changed the locks or something and won't let me in? What do I do? Well, I think the answer is you try to take them to court and get a judge to say what should happen, because we don't want to be in the wild, wild west. We don't want the things to get ugly and for police to be called. And I don't think that's what any of the landlords out there want either. But certainly for tenants, it's not. That's why we have a court system, and that's why. So that's where the place to take the dispute.
From a landlord, we've got a substantial damage property question. We have a tenant who's repeatedly flooded the unit below theirs. Would that be substantial damage to the property, do you think?
I would look at the reason why the flooding happened. If it's something that the tenant is doing on purpose, I think the statute uses intentionally, willfully, or negligently. I don't remember. It has a handful of adjectives that it uses to describe when charges or when something is on the tenant versus on the landlord when it comes to repairs and property damage. So I would look at why it's happening. You know, if the tenant's doing it on purpose in a malicious way, I think that could be considered significant property damage. If it's something that's inadvertent, if it's something that's a plumbing issue, if it's something that the tenant doesn't even know is happening, I would say that that's not significant property damage. It's not in the executive order, but I think that other parts of the landlord-tenant law in Minnesota would exclude things that are accidents or that a tenant isn't doing on purpose from that part of the executive order that talks about significant property damage. So even though that's not in the language that the governor used, that's in other parts of the landlord-tenant statute in Minnesota. So again, it depends.
Okay, and we have a host of questions still, so we're going to try to rapid fire some of these. Wendy asked, I think Mary, you brought this up, what law requires 3 months notice if there's no lease and the person is not paying rent and there is no lease?
504B135.
That was a fast answer to a fast question. Here's another one. Does VAWA apply to men too?
It does. It is actually an unfortunate use of the word, you know, I mean, the law was written in 1992, I think, or 93, somewhere in there, early 90s. So I think I have to excuse the genderism of it, but yes, it applies to everyone.
Okay. From a landlord, we have a tax credit public housing unit, and listed on the lease, tenants in these units have to do recertification each year. Under material breach, if they do not comply with this, can they be evicted? And I guess I'd ask you to answer this without COVID-19 happening and during the pandemic, if you could give us a separate answer for each situation.
I'll take the easy one. No, during COVID, because it's not significantly damaging property or seriously endangering other folks if you don't do your recert papers.
I guess that means you get the hard one, Luke.
Yeah, I mean, we see breach cases for failure to recertify, and so I'll say, without saying, we certainly argue against those. That oftentimes it's not a material breach. There might be other defenses. Reasonable accommodation comes up sometimes when a person doesn't recertify. I mean, there are a lot of exceptions, but generally speaking, it's a breach of the lease to not recertify. And and I think it's usually a story you can sell to a judge, because you tell them, look, we're not getting any money from HUD for this tenant right now because they've refused to fill out the paperwork, and that is fairly successful. So, probably, is that better than maybe? Better than it depends?
Yeah, I think it's a lot more definite. Okay. Oh, sorry, things got moved around there in a second. Well, okay. Why does there need to be a written lease for the executive orders exceptions to apply? Couldn't an oral lease also potentially be violated by a tenant endangering the safety of others or damaging property?
I would argue that a oral lease wouldn't have terms to it, right? So, and it wouldn't have a right of reentry clause, which the case law in Minnesota says you need to retake the property. And so I think based on the language in the governor's order, based on how the case law looks in Minnesota, there needs to be a written lease. And that's the way the governor wrote the order.
Right. The right of reentry clause is a confusing thing to landlords that aren't, in this for a professional line of work or don't really know what might actually exist in their lease. I give a lot of landlord speeches, and one of the things I always stress is you need a lease that's built for this state. It's got to be a Minnesota specific lease. If you just Google up a lease, you're going to find one probably for New York or California pretty easily. But a Minnesota specific lease will have a right of reentry clause, which says, tenant, if you violate a term, I can evict you pretty much right away for violating that term of the lease. And so an oral lease is very unlikely to have any kind of right of reentry conversation where the landlord would actually say out loud, hey, you can move in here. It's $500 a month. I'll, give you the keys in the first. If I see a dog here, then I can evict you. Okay, maybe that's the reentry clause stated out loud, but the landlord would have to prove that. And that might not be exactly what the tenant remembers hearing. So a right of reentry clause is one of those sort of basic things that needs to be in a Minnesota specific lease for every landlord, or else not just COVID-19 time, but any time it hinders their ability to file an eviction. Okay, let's see here. Can a landlord, this is anonymous, can a landlord evict a resident if the resident does not move out by their proper notice to vacate date? So I think that means the tenant gave a notice to vacate and didn't go.
Not right now. Right? Rapid fire, short answer?
Yeah,
Good?
that was it. That is absolutely right. Yeah, under the state moratorium, I agree with you. That's right. Okay, from a landlord, what if the person does not have a lease and if the person is claiming to harm themselves?
I would say no for the same reasons 2 questions ago, right? The only way that that comes in is under a written lease with a right of reentry clause, material violation. So I would say no.
Okay. Eric, I know you're crossing some of these things off. I'm jumping over to the chat box now. Is it better to have tenants ask for a written lease after their first year? Can just cause issues be affected by this? Wow, there's a lot built into that question.
Yeah, so it sounds like maybe from a tenant's advocate.
I think that's right, yeah.
Okay. I think, and I'm sure Homeland does the same thing. We typically advise people to get a written lease. Like, you want that thing in writing. I mean, you might be able to exploit the lack of a right of reentry clause at some point down the road, but it's still just better from any standpoint to say, like, let's have a written lease. Now, yes, if a tenant can convince a landlord to write a just cause notice provision or a just cause provision into a lease, absolutely, those are protective. And it's basic. It just says that if you want to kick someone out, you have to tell them why, and you maybe have to have like a set of particular reasons why before you can terminate that lease. Otherwise, the default is that landlords don't need to provide a reason at all in order to terminate a tenancy. And so, yes, I think if you can get it, I would say a written lease from day one, and yes, get a just cause provision written into it if you can. Most landlords will probably tell you no, but it's worth a shot.
Okay, and so Wendy actually chimed in on this as well. I think that if a tenant is thinking of not moving out after giving notice and the landlord has relied on that notice, you need to advise, I guess that's us, the tenant, that they could later be sued for the damages the landlord suffers from their refusal to move out. They can't be evicted, but they could be sued later. Yes,
and we do. I mean, believe me, we do. And we advise tenants that they can be sued for the unpaid rent, and and that's racking up as well. And yes, we advise them that.
Sure. Okay, the tenant has changed the locks, so the landlord doesn't have access to the unit to make repairs. What do we do? This is from a landlord, I assume.
I think that goes back to the questioner from earlier, where Luke talked about self-help and how we have a court system for just these kinds of things. So I think the remedy would be going to court and seeing what a judge would do.
Okay. Some jurisdictions have penalties for a plethora of spurious cases. Wow, wow, a lot of good language there. Do these penalties exist here?
Well, there are rules that say that you can't bring a court case that's frivolous. You can't bring one that you know has facts in the complaint that aren't true. And there are penalties now under the executive order if things are brought in violation of that. The penalties are, and I don't recall if Mike or Luke talked about, which one of you guys talked about this, that those are enforced by the Attorney General's office. So yes, there are some mechanisms like that in Minnesota.
Okay.
Just to quickly jump on that, I know we want to move fast, but I know I didn't mention this earlier that there's over 150 evictions that have been filed in Hennepin County that have not been scheduled for hearings because the court has deemed them not to meet one of the exceptions. And so just for landlords out there, I mean, I think there was some misinformation going out to like get earlier in the queue by filing these cases, even though there's clearly no basis for them under the existing moratorium. And I would say, I would not do that. You're wasting $300. The judges have said clearly that they're going to dismiss and expunge those cases immediately. And then on top of that, you're breaking the law. And in theory, the Attorney General could fine you $1,000 and convict you of a misdemeanor. So I'd say don't do that. And you're bogging everything up. And if anything, it's going to make it harder to get evictions filed once the moratorium is lifted because they're going to have to clear out all those backlogged cases.
Okay, if there's a written lease, but the lease doesn't have any language prohibiting threats, violence, property damage, would a landlord still be able to file an eviction under COVID-19, the exceptions that the governor has in the executive orders?
I would argue no, that it has to be a provision of the lease that is explicit and clear that the tenant is materially violating. I would also add on to that it has to be a legal and enforceable lease. So in Minneapolis, the Minneapolis code requires landlords to have a rental license. And if a landlord doesn't have a rental license during a time a lease is executed, we've had success with the court saying that that lease is invalid. It's an illegal contract. And so a tenant can't be evicted for violating terms of an illegal lease.
Would changing the locks, the tenant changing the locks, be considered substantial damage? Or significant damage, I guess would be the right phrasing under the executive order.
I would say no.
I mean, the exception is like if they're preventing a landlord from fixing some problem that's causing significant property damage. I mean, it kind of feels like we're on a variation of the same sorts of questions. And I mean, I can see a scenario where a tenant's like not allowing a landlord in, but there's some major property damages in the property that so there's a possibility at least that case could be successful.
Okay, from Janelle, can a right of re-entry be used now in the COVID times? I think what she's asking is, I'm not exactly sure what she's asking. She might be asking, is that enough? Or do you still have to comply with the governor's exceptions to be able to use that right of re-entry?
The latter. So you have to still either be in the significant property damage bucket or the seriously endangering others bucket.
Okay. You know what, we have probably 10 other questions, but most of them are slightly off what the sort of central topic has been today. And it's, well, it's 3 o'clock. And I know that you guys are both busy and we don't want to take any more of your time. You've answered a lot of questions that weren't asked, but a lot of them that were asked as well. It gave a lot of good information. Eric, did you want to follow up with any last questions for either of these legal aid lawyer expert types?
I just want to thank you again for both being a part of this today. It's been very, very interesting and helpful. And we did put your information back up on the screen. I did put in the chat the intake line. And so very much appreciate you both being on today. And a reminder, You want to talk a little bit about 2 weeks from now, Mike?
Yeah, we're going to do quite a bit deeper dive on numbers of evictions that have been filed around the state, along with the reasons that landlords are listing for evictions to be filed. Once again, any of you that are lawyers that are watching out there, we're going to be applying for CLE credit for the next speech. We have not done that for every one of these sessions, but when there's sort of a really more focused legal topic, then we've done that. Yeah, we're going to look and see what the cases have actually been about. We got some nice examples from Luke and Mary today, but we're going to be looking sort of at a general overview of the types of evictions that have been filed, how often they were filed. Was there a spike after each change in the governor's eviction orders, things like that. So it's going to be an analysis, sort of the history of COVID-19 evictions up till now.
Yeah, and we also are going to apply for today's to be CLE credit. So there'll be a recording available of this on our website, and we'll follow up with participants from today about if and when CLE credit gets approved, as well as the information and registration for the event happening in 2 weeks. So with that, we'll say thank you. And again, to Mary and Luke, really appreciate you being on today. And thanks for your advocacy and your work in this field.
Yeah, likewise. Thanks for doing this and thanks for having us.
Thanks,
All right.
guys.
Have a good day.
Bye.
Bye.